welcome to the PRP Search Basic Training Session 2, Liability Overview. My name is Carlin Prisk. I've been an investigator in Region 3 Superfund program since 1998. Many of the things we'll be covering in this session may require the input and legal counsel of your attorneys, and I encourage you to work closely with them in your investigations. So let's get started. You may have noticed that people tend to use the term PRP interchangeably with liable, or in other programs like the Underground Storage Tank Program, RP, or responsible party. But the terms are really not interchangeable. A PRP, in simplest terms, is a potentially responsible party. The term PRP arguably includes anyone you investigate in connection with a site, whether or not that person ends up being liable under CERCLA. You will conduct a PRP search, but it's entirely possible, even probable, that not every potentially responsible party investigated will also be legally liable under Section 107A of CERCLA. Where CERCLA doesn't define the term PRP, it does define the elements of liability and the types of liable parties. Under CERCLA Section 107A, a person is liable for response costs, including the cost of collecting them, when all of the following occur. There has to be a release or threatened release of a hazardous substance from a facility into the environment that causes response costs to be incurred, and a person falls within one of the defined categories of liable persons under CERCLA. Section 107A of CERCLA defines 4 categories of PRPs: the current owner or operator, an owner and operator at the time of disposal of hazardous substances, the person who arranged for the disposal or treatment of hazardous substances, and a person who transported hazardous substances. Where 107A defines the types of liable parties, 107B provides several statutory defenses to that liability. The first 2 of those statutory defenses are an act of God and an act of war. To invoke these statutory defenses, a party must demonstrate that the release of a hazardous substance from a facility into the environment was caused solely by an act of God or an act of war. Pretty straightforward, right? But not so fast. Courts have held that these defenses do not apply to events that could be anticipated, such as heavy rains or earthquakes. Rather, these statutory defenses would be limited to an exceedingly rare and unforeseen set of circumstances. The third statutory defense to liability provided by Section 107B of CERCLA is that the release was caused by an act or omission of a third party. In simplest terms, that means that the release or threatened release of a hazardous substance from a facility into the environment was caused by the action or failure to act of someone other than the PRP. Because this, like act of God and act of war, is a defense, not an outright exemption to liability, it is the burden of the PRP to prove it. That's where it could get tricky. The PRP has to demonstrate first that it had no direct or indirect contractual relationship with the third party. Contractual relationship is defined in Section 10135, and we will talk about it in some depth in a moment. To invoke the third party defense, a PRP must also demonstrate that it exercised due care with respect to the hazardous substances, and that it took precautions against foreseeable acts or omissions of any such third party. We'll come back to this shortly, but let's move on to some of the exemptions to liability. CERCLA provides an exemption at Section 114C to the owners of service stations that manage recycled oil. Service station owners are exempt from liability so long as that recycled oil is not mixed with other hazardous substances, and the service station owner is in compliance with other laws and regulations. Another exemption applies to state and local governments. According to Section 107D, states and local governments are not liable for their actions taken during an emergency response at a facility owned by another person, unless there was negligence or misconduct. In 1996, Congress passed the Asset Conservation, Lender Liability and Deposit Insurance Protection Act, the Lender Liability Amendment. The exemption, which was codified at CERCLA Section 10120A and E, protects lenders who hold indicia of ownership, primarily to protect a security interest in the facility, and who don't participate in the management of a facility. So, for example, a secured creditor who holds a deed of trust for a facility but does not participate in the management of that facility would not be liable under Section 107A. In 1999, the Superfund Recycling Equity Act, the Recycling Amendments, provided exemption from liability to arrangers and transporters who arrange for the recycling of recyclable materials, such as scrap paper, plastic, glass, textiles, metal or spent lead acid, nickel cadmium, and other batteries. Section 127 of CERCLA lists specific requirements for qualifying for the exemption, as well as exclusions to the exemption. Section 127 requires a very fact-specific analysis to determine whether a party actually meets the requirements of the statute. You will need to work closely with your site attorney to develop and analyze the facts in this regard. While we're on the subject of amendments to CERCLA, the Small Business Liability Relief and Brownfields Revitalization Act of 2002, the Brownfields Amendments, amended CERCLA to provide important liability limitations for innocent landowners at Section 10135, for contiguous property owners at 107Q, and for bona fide prospective purchasers, or BFPPs, at 107R and 10140. As you will see in a moment, these three exemptions share a number of common elements. To qualify as an innocent landowner, a person must meet the requirements of CERCLA Section 10135 and Section 107B3. Both of these citations should sound familiar to you. To start, innocent landowners cannot have a contractual relationship with the third party who caused the release of hazardous substances. According to Section 10135, contractual relationship includes, but is not limited to, land contracts, deeds, easements, leases, or other instruments transferring title or possession, unless the real property on which the facility is located was acquired by the defendant after the disposal or placement of the hazardous substance on, in, or at the facility, and one or more of the circumstances described in Clause 1, 2, or 3 is also established by the defendant by a preponderance of the evidence. Let me break that down a bit. A contractual relationship includes things like land contracts, deeds, easements, leases, and the like. To be an innocent landowner, a person must establish that the property in question was transferred after the disposal of hazardous substances occurred, and that one of three things can be established. The first of those three things is that at the time the party acquired the facility, it did not know and had no reason to know that any hazardous substance was disposed of there. Second, that the party is a government entity and acquired the property involuntarily, for example, through eminent domain or condemnation. Or third, that the party acquired the property by inheritance or bequest. A few minutes ago, I said that innocent landowners have to meet the requirements of 10135 and 107B3. Remember that Section 107B sets forth the statutory defenses to liability. Innocent landowners have to meet the requirements of the third of these, the third-party defense to liability. The PRP has to demonstrate that it had no direct or indirect contractual relationship with a third party, demonstrate that it exercised due care with respect to the hazardous substances, and prove that it took precautions against foreseeable acts or omissions of any such third party. But that's not all. Innocent landowners must also provide full cooperation, assistance, and facility access for the response action. They must remain in compliance with any land use restrictions established or relied on in connection with the response action, and they cannot impede the effectiveness or integrity of any institutional controls. To back up a bit, innocent landowners have to have no contractual relationship with the party causing the release. They have to acquire the property after the disposal of hazardous substances and establish one of three things. The first being that the person did not know and had no reason to know that hazardous substances were disposed of there. Section 10135 also adds an additional burden to demonstrate that the person had no reason to know that hazardous substances were disposed of on the property. To do that, on or before the date on which the person acquired the facility, he or she must conduct all appropriate inquiries in accordance with the standards set forth by EPA's regulations. And the innocent landowner must take reasonable steps to stop any continuing release, to prevent any threatened future release, and to prevent or limit any human, environmental, or natural resource exposure to any previously released hazardous substance. The Brownfield Amendments also excluded from the definition of owner or operator a person who owns property that is contiguous or otherwise similarly situated to a facility that is the only source of contamination found on his property. Contiguous property owners didn't cause the release, didn't contribute to the release, and did not consent to the release. They are only guilty of being the unfortunate neighbor of someone who did. To qualify as a contiguous property owner, a landowner must meet the criteria set forth in CERCLA 107 Q1. Like innocent landowners, contiguous property owners must not be a PRP or affiliated with a PRP and perform all appropriate inquiry prior to purchasing the property. Persons who know or have reason to know prior to purchase that the property is or could be contaminated cannot qualify for the contiguous property owner liability protection. Like innocent landowners, contiguous property owners must take reasonable steps to stop continuing releases, prevent future releases, and limit exposure to hazardous substances. They must also comply with land use restrictions and provide cooperation and access. The Brownfields amendments also created a new category of parties protected from liability, the bona fide prospective purchasers, BFPPs. BFPPs are defined in Section 10140 as parties that acquired contaminated property after January 11, 2002, and who acquired the property after disposal occurred there and are not a PRP or affiliated with a PRP. BFPPs must also make all appropriate inquiries in accordance with prescribed professional standards and must exercise reasonable care to stop continuing releases, prevent future releases, and limit exposure to hazardous substances. Finally, BFPPs must comply with land use restrictions, cooperate, provide access, and comply with information requests. Those requirements should sound very familiar at this point, as they are shared as common elements by innocent landowners and contiguous property owners. One area in which BFPPs differ from innocent landowners or contiguous property owners is that EPA is able to recover some costs from BFPPs in spite of the exemption to liability. The amount of costs that EPA can recover from BFPPs is limited by Section 107R of CERCLA, which establishes a windfall lien where certain conditions are met, namely where there is a response action for which the United States has unrecovered response costs, and where the response action increased the fair market value of the facility. EPA's lien is equal to this increase in the fair market value, regardless of what the actual costs are. Like EPA's traditional 107L liens, the windfall lien might only continue until the lien is satisfied or the statute of limitations expires. The Brownfields amendments also codified the limitations on liability for residential, small business, and nonprofit generators of municipal solid waste, or MSW, at Superfund sites on the National Priorities List, the NPL. One last thing the Brownfields amendments did was to put protections in place for the tiniest contributors of hazardous substances, the de minimis parties. De minimis parties are those that contributed less than 100 gallons or 200 pounds of hazardous substances to the site. They are statutorily protected from liability. In addition to these defenses, exemptions, and limitations to liability, EPA also has broad latitude in applying its enforcement discretion. There are several long-standing policies that allow us to take special action for situations where there is an orphan share, de minimis parties, or where a party has a limited ability to pay EPA's costs. The orphan share policy allows EPA to give a break to parties performing the work at a site or paying EPA's past costs. The orphan share accounts for PRPs who are defunct or otherwise not viable. EPA essentially absorbs the share of its costs for those orphan parties rather than seeking to recover them from the liable parties. EPA also has a policy of settling with de minimis parties as early as possible. A de minimis party is one whose contribution to the site is comparatively minor in terms of both volume and toxicity. EPA's de minimis settlement authority is found at Section 122G of CERCLA. EPA also recognizes that there may be limitations on the ability of liable parties to pay EPA's costs at the site and has the authority to settle based on an analysis of a party's finances. EPA also has long-standing guidance on how to treat owners of residential property where EPA has to respond to releases of hazardous substances, and owners of contaminated aquifers. Generally, in both of these situations, EPA will not pursue cost recovery. So where does the PRP search fit into the enforcement process? PRP search activities can and should take place at all stages of a response action, from discovery and initial investigation of a site through cost recovery. Because of EPA's enforcement first policy, it is essential that the PRP search get started as early as possible and to be updated as needed. For example, a PRP search may start when an on-scene coordinator goes to a site to conduct a removal assessment. It will continue through the completion of the request for funding for a removal action, with which EPA initiates a fund lead action. There may very well be additional areas of research that need to be conducted or followed up on during the removal, so that if a viable and liable party is identified, EPA can consider having it take over the removal action or pursue it in cost recovery. In addition, prior to sending a demand for payment of response costs, known as a demand letter, or making a decision not to pursue cost recovery at a site, the PRP search should be reviewed and updated as needed. For a remedial site, EPA might begin the PRP search as soon as or even before a site is proposed to the NPL, with the goal of having the preliminary search completed before the remedial investigation and feasibility study begins. Like a removal action, the PRP search will continue as leads are followed up on and new information is developed, with the goal of identifying liable parties who can complete the remedial design and remedial action at the site. Prior to cost recovery, the PRP search should be reviewed and updated as needed. You may also need to update certain information like title searches at the 5-year review process. If we have PRPs who are both liable and viable and willing to negotiate, we have 2 settlement options: administrative or judicial settlements. Administrative settlements are agreements between EPA and the liable party and do not involve a court, although EPA can go to court to have administrative settlements enforced. Administrative orders on consent are typically used for removal actions, remedial investigation and feasibility studies, and remedial design. In contrast, judicial settlements are in the form of a consent decree and have to be lodged in federal court. Judicial settlements generally take longer because they have to include the Department of Justice, and once the settlement is lodged with the court, it is open for public review and comment. Once the comment period closes, we then have to ask the judge to enter the consent decree, at which point it becomes effective. Judicial settlements are typically used for remedial actions and cost recovery. If liable parties are unwilling or unable to do the work required at a site, EPA can seek to recover its costs. If there are liable parties, EPA may choose to send a demand letter. Demand letters notify the PRP that EPA has incurred costs and wants the recipient to pay them. It also starts the clock ticking for accrual of interest, which liable parties have to pay. EPA's demands may include everything the United States, including DOJ and ATSDR, have spent, not just the direct work costs, but also the costs related to enforcement and all of EPA's overhead. EPA's indirect rate, which includes all those costs that can't be specifically assigned to a particular site, things like overhead, headquarters costs, lab operation costs, etc., tax on another 50 to 76%, depending on the region and the year, to the bill. So for every dollar we've spent, EPA may bill $1.76. In a perfect world, the demand letter prompts the liable party to come in and pay the United States costs, either by writing a check or by entering into some kind of settlement. In an imperfect world, EPA may have to ask DOJ to file a complaint against the liable parties in federal court and try to reach a settlement that way. In either case, perfect or imperfect world, EPA's cost documentation is crucial. EPA has to show what was spent and when, must prove that work was authorized and complete, and demonstrate that the costs have been incurred and paid. This concludes the Liability Overview, Session 2 of the Basic PRP Search Training. This training is not intended to be a comprehensive explanation of all aspects of liability, so I encourage you to work closely with your site attorney on your investigations. Please send us your feedback about this course by visiting our website. You will also find resources and references relevant to this session on our site. Thanks for watching.